It's tried to state that every case depends to a large extent on its own facts. My learned friends have taken recourse to some facts, but I propose to deal more substantially with facts and only incidentally with the law, because a lot has been said on the law. To point out, Manoj, that the fundamental propositions of law which my learned friends have raised in this case, on the facts of this case, don't arise at all. But Mr. Salve has said something on it in his brief submission. I'll just expand a little on it. But essentially, the 2 points of law, as I understand, in sum and substance, what it boils down to is A, the question of deemed disqualification. But to use that term which they've sometimes used and sometimes steered away from. The question of deemed disqualification, i.e., they were liable to disqualification. The disqualification never took actual place, but they were liable to be disqualified. And consequently, as a result of that deemed disqualification, the second proposition of law, and that is that the court must set the clock back, relying mainly on Rana, again, extensively dealt with by my learned friends, Mr. Salve and Mr. Kaul, and set the clock back completely, because the concept of deemed disqualification, since it dates to the date when the acts entailing disqualification took place, are the ones that are relevant for the purpose of disqualification. So you must look at that time. Now, not a brief conspectus of facts. Now, as I pointed out earlier, when we were dealing with referral, there's a very short time span, and that's between 21st and the 4th. Well, it's important to note that while discontentment and division commenced from the very inception of the post-poll alliance of the MVA government, the commencement of irreconcilable differences occurred on 21st June. That's the first date. The differences chiefly centered around the disinclination to continue with the MVA alliance, which, as per the EKNATH Shinde group, was causing serious turbulence among party cadres for 2 reasons. The Shiv Sena had entered into a pre-poll alliance with the BJP for the elections held in November 2019, and their voters and cadres were aggrieved by the betrayal of that pre-poll alliance by the constitution of the MVA coalition government. And 2, that the party cadres were finding it difficult to reconcile long-standing ideological battles with their coalition partners, namely the Congress and the NCP, and the cadres of the different party in the coalition, far from working in cohesion, were at loggerheads with one another. Now, there are many statements even before the 21st. Ministers of the then Shiv Sena, the joint Shiv Sena, many statements expressing dissatisfaction in public. MLAs have complained about it. So this is all, 2021st is the only date which this court has a record of. But it happened much earlier. Now, the first steps, as per the record of this court, that led to the rendering the differences irreconcilable were admittedly initiated by the Uddhav Thackeray group. One of the first salvo was filed on 21st June by the Uddhav Thackeray group. In its resolution of 21st June 2022, a minority of members of the Shiv Sena Legislative Party in the Assembly removed Eknath Shinde from the post of group of Shiv Sena Legislative Party, of leader of the Shiv Sena Legislative Party. On the same day, the chief whip, one Sunil Prabhu, issued a party whip summoning all members of the Shiv Sena Legislative Party to attend the meeting at the CM's residence on the same day. The removal of Eknath Shinde, this is where it starts, because my Lord Justice Kohli was asking about, could there be no reconciliation? Was there no party forum to resolve these differences? The first salvo that was filed was on 21st June, and it was a very drastic salvo filed. The salvo was you remove him as a legislative leader. After that, it became irreconcilable. Nothing could be done. And I'll tell your Lordship what happened afterwards. Those facts are very important as to why the party forums became irrelevant. What was done by the party organization and the party leaders, including people in their party leaders in parliament? The removal of Eknath Shinde as a leader of the legislative party indicated an intention on the part of the Uddhav Thackeray faction to escalate a simmering dispute to a point of no return. Now, neither the resolution nor the whip issued by the chief whip were communicated to any of the Shiv Sena MLAs who were not signatories to the resolution. Eknath Shinde and the other MLAs only learnt about the resolution and the whip on 21st June through media reports of the same day. On its part, the Eknath Shinde group, consisting of 34 MLAs, passed a resolution on the same day setting out various grievances with the party leadership for forming the MVA government and the impact that it had on the party, its organization, cadre, and voters. Now, my lord, all this has been read, so I'm not going to read in detail. But, my lord, your lordships will recall that the letter of 21st June was a response by Eknath Shinde to his removal, in which he pointed out that it was not just the legislators, but it was also the cadres who were disappointed. So the organizational disappointment along with the legislator disappointment were both highlighted in that letter of 21st June, which, as I said, was a response to their letter. By the resolution, 34 MLAs reaffirmed Shinde as the leader of the Shiv Sena legislative party, removed Sunil Prabhu as the chief whip with immediate effect, and appointed Mr. Bharat Gogable as chief whip in his place. The resolution was sent, this is important, my lord, the resolution was sent and received by the governor of Maharashtra. So the governor of Maharashtra, to answer again, my lord, Justice Kohli's, had his first intimation of a simmering dispute on the 21st June. The resolution was sent and received by the governor of Maharashtra, the deputy speaker of the Legislative Assembly, and the secretary of the Maharashtra Legislative Assembly, both by email and a hard copy. The 34 MLAs on the same day, we are still on 21st June, also sent a notice to the deputy speaker, Mr. Zirwal, of intention to move a resolution for his removal under Article 179C of the Constitution, read with Rule 11 of the Maharashtra Assembly rules. And I'll read those rules in a minute, because they are quite important. They deal with the 14-day period notice prior to consideration. And the rule and the article are both mentioned in that letter sent to the governor and the deputy speaker. On the ground that he no longer enjoys the support of the majority of the House and accordingly has lost his right to continue as deputy speaker, in view of the decision in Navam Rebia, the deputy speaker was requested to refrain from acting as deputy speaker till such time as he could prove the support of the majority in the House. Now, my lord, what are the contentions of the petitioner? First, that if the respondent had a grievance with the party leadership, he ought to have sorted it out within the party and not sent the notice under Article 179C to the deputy speaker. That the notice of the deputy speaker was flawed because in any event, the deputy speaker's disability under Article 181 commenced on a consideration of the notice of a resolution for removal and not when notice had been given of the intention to move the resolution under Article 179C. The decision of Navam Rebia, to the contrary, needed reconsideration. And the resolution of 34 MLAs of Eknath Shinde group was without jurisdiction as Eknath Shinde had been removed as the leader of the legislative party in the House. That's by their letter of 21st June. Now, my lord, this is the response of the... As regards the reply to 2.1 above, the question of resolving grievances against the leadership within the party did not arise, as the party leadership had precipitated the issue and made any reconciliation impossible by unilaterally and illegally removing Eknath Shinde as leader of the legislative party. Well, no hearing, no notice, nothing. This unilateral removal had to be viewed as a hostile act, which would be followed by more serious consequences. In the circumstances, the letter to the deputy speaker under Article 179C was a protective step against any escalation by the Uddhav Thackeray group. Significantly, at this stage, now this is important, the Eknath Shinde group did not take any step in the direction of unsettling the government by withdrawal of its support, necessitating a floor test. Now, my lord, on the applicability of Nabam Rabia. Although on facts, it's my respectful submission that Nabam Rabia's, the case doesn't arise at all on the facts of this case. Nevertheless, my lord, if your lordships do intend to say something about Nabam Rabia, my lord, this is my respectful submission that it should be to reaffirm, especially Justice Mishra's view. My lord, I concede that the then members' part of 179C has been wrongly construed, particularly in view of the Constituent Assembly debates, and particularly the view of Dr. Ambedkar in that. But, my lord, there's much more to be said apart from the then members' part of it, for reaffirming Justice Mishra's very eloquently put view in that separate judgment. On the applicability of Nabam Rabia, the construction of that judgment regarding the time when the Speaker's disability under Article 181 commences was established law by a constitution bench, and the Deputy Speaker was bound to act according to its dictates. Well, that's an aside. In any event, whether you like Nabam Rabia or not, the Deputy Speaker was bound by its mandate, and its disobedience at that particular point of time is a serious breach on his part of his duties and the role envisaged for him by the Constitution: impartiality and, of course, obedience to the law. As regards the correctness of the view taken on this aspect in the decision in the Nabam Rabia, it is respectfully submitted that this honorable court should reaffirm the view in Nabam, most emphatically enunciated by Justice Mishra, that when there is an expression of intention to move a resolution. Now, may I just read paragraphs 236 and 238 of Justice Mishra, just 3 paragraphs at this stage. It's PDF 1167. Well, because, my lord, he makes the case for what he says compelling. (236). In this regard, lordships, it is essential to understand the character of the 10th schedule. The 10th schedule to the Constitution has conferred adjudicatory powers on the Speaker. While deliberating on the constitutionality of said schedule, the majority in Kyoto's case has stated, the Speaker Chairman, while exercising powers and discharging functions under the 10th schedule, act as tribunal adjudicating rights and obligations under the 10th schedule, and their decisions in that capacity are amenable to judicial review. However, having regard to the constitutional scheme of the 10th schedule, judicial review should not cover any stage prior to the making of a decision by the Speaker's chairman. Having regard to the constitutional intendment and the status of the depository of the adjudicatory power, no quia timet injunction actions are permissible. Now, I'm not pausing there for a minute. If there is a constitutional violation by the Speaker, the actual order of disqualification, that is not contemplated by Kyoto's judgment. For instance, when he did not comply with the notice period, and that notice period is under Rule 8 of the 10th schedule, a court could intervene, because that was a denial not only of natural justice, but a contradiction of the rules framed by them in their wisdom under Rule 8, under Clause 8 of the 10th schedule. And Kyoto says something about the sanctity of those rules. I'll come to that later. At para 6.1 of the 10th schedule, to the extent it seeks to impart finality of decision of the Speaker's chairman is valid, but the concept of statutory finality embodied in paragraph 6.1 does not detract from the abrogate judicial review under Articles 136, 226, 227 of the Constitution, insofar as infirmities based on violations of constitutional mandates, malafide, non-compliance with rules of justice, and perversity are concerned. But Kyoto says more on paragraph 8 rules, and I'll come to that. Now, the rest of that is, you'll also just see J, that contention that the investiture of adjudicatory functions in the Speaker's chairman would by itself vitiate the provision of the ground of likelihood of political bias is unsound and is rejected. The Speaker chairman hold a pivotal position in the scheme of parliamentary democracy and are guardians of the rights and privileges of the House. They are expected to and do take far-reaching decisions in the functioning of parliamentary democracy. Vestiture of power to adjudicate questions under the 10th schedule in such constitutional functioning should not be considered exceptionally. Now comes Justice Mishra's own enunciation. The aforesaid reasoning eloquently speaks of the power, position, and the status the office of the Speaker enjoys under the Constitution. It also states about the scope of the fiction. The court has constricted the power of judicial review and restricted it to the stage, carving out certain extreme exceptions. It is because the Speaker, while exercising the authority stroke jurisdiction, exercises the power of constitutional adjudication. The concept of constitutional adjudication has constitutional value in a parliamentary democracy, and constitutional values sustain democracy in a sovereign republic. The Speaker is expected to maintain propriety as an adjudicator. My Lord, when I show the facts of this case as subsequently transpired, I will show your Lordships that the Speaker repeatedly violated his constitutional duty as envisaged. The Speaker, when functions as a tribunal, has the jurisdiction authority to pass adverse orders. It is therefore required that his conduct should not only be impartial, but such impartiality should be perceptible.
In trying to tell the learned judge about how the matter arose and what was the issues here. So we'll, yes.
Honored. We're all honored.
On behalf of the bar, we welcome the Chief Justice.
Here with us. The other colleagues of Chief Justice Mata Kuma here, the Deputy Chief Justice. So we welcome all of you as well in our midst, and hope that you will keep on visiting our court and country more often.
Thank you.
Yes, Mr. Jethmalani.
My Lord, I was reading paragraph 237.
Instead of reading the 17-page note, why don't you formulate what the essential points are?
Yes.
Yeah, so that then we can, we know where you stand.
But at the end of each, I was going to make my proposition. At the end of each. So I just finished this.
Why don't you formulate what you have to say, so that we'll read the note. There's no difficulty.
Yes. May I just finish reading 237 and 238, or it's not? Your Lordships are familiar with it.
We've already read that judgment.
Continue from your note.
I'll read.
Or if you can formulate what your submissions are, isn't that? That may be better. If you can.
So as I said, my submission on this aspect of the matter, first, of course, it's not necessary to go into any revisit of the judgment in Nabam Rabia. But if your Lordships do want to revisit it, it should be for reaffirming the view enunciated, in particular by the decision of Justice Mishra, which is that he's disabled. A speaker or a deputy speaker is disabled for his functions as a speaker at the time of a notice to remove him, and not at a subsequent stage when that notice is under consideration.
Yes.
Now, so that view, my Lord, sir, I'm now reading page 6 of my note, is fortified by the following submissions. The fact that a prior notice of 14 days is to be given, has your Lordship's got that, my Lord? I'm at page 6 of my note. Presents every opportunity to those aggrieved by the said notice to thwart the intention of the notice. A speaker or a deputy speaker whose removal is intended will be tempted to take all steps available to him to dissuade or prevent the mover of the motion from proceeding with it further in that 14-day period. So that 14-day period provides him an opportunity which not only is capable of being misused, it had been misused, and I showed that particularly with reference to the facts of the instant case. And that's my second proposition, that subsequent events revealing gross misconduct and partisanship on the part of the deputy speaker, as more particularly set out here, and I'll come to those, during the 14-day notice period, vindicate the view in Nabam Rabia regarding the period when the deputy speaker's or speaker disability under Article 181 commences. Then third, number one, Article 181 deals with a situation where the resolution for the removal of the speaker is under consideration and prescribes the restrictions on the speaker or deputy speaker that at a sitting, that article is concerned with a sitting of the Legislative Assembly. Please note that, my lord.
Yes.
At a sitting of the Legislative Assembly, when such resolution is under consideration, then the deputy speaker or the speaker, as the case may be, shall exercise all the powers available to a member of the Legislative Assembly, but not those that pertain to the office of speaker stroke deputy speaker. Now, my lord, this is logical. I'm sorry.
Yes.
This is logical as the notice for removal is from the office of speaker, deputy speaker, and not as a member of the Legislative Assembly. While Article 181 uses the word any resolution and not notice of intention for removal of the speaker, that is because while consideration of the resolution has to be during the sitting of the Assembly, or it can only be when the House is in session, a notice of intention can be given even when the Assembly is not sitting. So Article 181 itself does not prohibit a construction that a deputy speaker cannot act as such deputy speaker from the time a 179C notice is moved. 181 deals with a sitting for consideration of the Legislative Assembly. And below the rules between 179C and 181, that is notice given and then 181 consideration of the notice, there is a vacuum. That vacuum is filled up by Rule 11. The House itself has made rules as to what will happen in that interregnum. But if the Lordships want, I'll read it very quickly. Rule 11.
That's all right.
Not
We've seen the rule.
We have seen Rule 11.
So that in short, my lord, he has to give a notice 14 days period, and then as soon as may be. But the House rules make it almost impossible for there to be any serious delay in the matter pertaining to disposal of this issue of his removal. Because it's only that 14-day period. Immediately after the 14-day period, he has to refer it to the House. And then, so basically it's 14 days. And
So according to the prohibition, the period when the speaker is barred from considering a petition for disqualification commences the moment a notice is given.
yes.
Commences the moment a notice is given.
And any misuse is circumscribed by the rules of the House, which say immediately after the 14 days almost, you must put it up to the House. If you get 29 members, it will then be considered. You don't get 29 members after 14 days, the issue is dead and then.
All right. What is the next point now?
Then the provisions of Article 181 of the Constitution are based upon the rule against one being a judge in one's own cause. In other words, the nemo judex in cause sua rule. There is no reason why this rule should be restricted to the case of consideration of resolution, but not at the stage of notice, when a speaker who continues to function as a speaker can use his powers as a speaker to alter the constituency that will decide on his removal. So he can gerrymander the constituency that decides on whether he should, if he's allowed to remove them. And that's the whole purpose of. Now, the Lordship will kindly have, what is it that is prevented by 179 or 181? It is that the speaker cannot preside. He cannot preside over the House. That word is important. By presiding over the House, he gets several powers, which can, my lord, and his powers, at least under our constitution, are almost paramount. They're unchecked. His is the last word. Regarding procedure in the House and decisions taken, his is the final word. There's no check on it within the House. It's only governed by the rules. That's it. Now, my lord, your lordship will quickly see two rules which have not been pointed out so far. Rules 53 and 58 of the Maharashtra Assembly Rules, PDF 34 and compilation 3C.
Read the PDF page.
PDF 34. 34. My lord, it is the possible abuse of his power to preside that has warranted 181, that has brought 181 into existence. Now, under Rule 53, for instance, I'm just giving an example as to what he can do to scuttle the constituency, to scuttle the number of members who might vote against him. The Speaker may direct any member who refuses to obey his decision or whose conduct is in his opinion grossly disorderly to withdraw immediately from the assembly, and any member so ordered to withdraw shall do so forthwith and shall absent himself during the remainder of the day's meeting. Now, this is a part of suspension essentially. So on that day, on a particular day when he's being voted, he can resort to this power and there's no check. That is why his powers of presiding over the House are suspended when his motion is under consideration for his removal. Now, my lord, by a parity of reasoning, what applies here should equally apply to that 14-day period, because he can scuttle members during that time. In fact, as happened in this case, he can totally ignore the notice at all. A speaker prone to doing that, as he has done in this case, can well not scuttle the entire removal procedure. And I'll briefly remind your lordship at the appropriate time as to what he did in this case. So, for logical reasons, there is no ground to distinguish between the 181 stage and the 179 stage. The nemo judex rule will and must apply at both stages. Otherwise, you check him at the 179 stage, but he can scuttle the entire removal motion at the 14-day period 179 stage. '58 is an all. 58 of the rules is his residual power. He is the final residuary authority of all power in the House. All matters not specifically provided for in these rules and all questions relating to the detailed working of these rules shall be regulated in such manner as the Speaker may from time to time direct. So anything that's not provided for in the rules is at his sole discretion. That's how powerful he is. Now, my lords, that's the proposition. The proposition is that the judgment in Nabam Rabia must be reaffirmed and put on stronger ground for the reasons I respectfully submit I have advanced in this note. There may be something to say about the then member's part, but there are stronger grounds. This judgment can be put, this authority can be put on stronger grounds if your lordships are to revisit the judgment. Now, I come to the next factual conspectus, and that is now on 22nd June. On 22nd June 2022, Sunil Prabhu, acting as Chief Whip of the Shiv Sena Legislature Party, issued a notice calling all members of the SSLP to attend a meeting to be held at the CM's residence on the very same day at 5 p.m., failing which consequential action against the delinquent MLAs under the relevant provisions of the Constitution of India would be taken recourse to. The said letter was replied by Shri EKNATH Shinde on the same day, disputing the authority of Sunil Prabhu and further stating that Bharat Gogwavle had been appointed the Chief Whip of the SSLP. It was also said in the same letter that the notice was invalid, PDF page 51. In view of non-attendance by Shinde and other MLAs of the Shiv Sena, an illegal resolution was passed. Now, please note, they didn't attend that meeting. for that very elementary ground, a notice was then issued. A resolution was passed by 14 MLAs of the UT faction to take disciplinary action as provided under. So this is the starting point. Disciplinary action under 10th schedule. For what? For not attending the meeting. Now, my lord, the contention of the petitioner is that the notices issued on 21st and 22nd were validly issued and were binding on all members of the Legislative Assembly. Our contention that the two resolutions of 21st and 22nd were illegal for the following reasons. Prabhu had been removed as the party whip by 34 MLAs of the EKNATH SHINDE group on 21st June itself. After he had been removed, he issued that notice or notices. The notices were therefore without jurisdiction. Now, not very important. Moreover, it is well settled that a party whip can only be issued for actions on the floor of the assembly and not outside the house. The party whips of 21st and 22nd June were misconceived and illegal insofar as their content was concerned. Now, my lord, over here, there's a new document which is not before your lordship, but we have filed it just now regarding the Legislative Assembly debates, the parliamentary debates pertaining to the 52nd Amendment in 1985. I'll just read the speech of one member. What is the reference? But it's the last document on record.
Last document means where? Where is it?
Is it scanned?
Well, we just filed it in the lunch break. I'm sorry, my lord. We just discovered this document.
All right, you can just refer to it.
Now, my lord, this is the speech. What happened, my lord? And there's another provision.
Who is the speech by?
By Sharad Dighe, one of the members of Parliament in the Lok Sabha, who said this. Now, what happened was, originally, the bill had 3 provisions under 2. 2A as it presently stands, 2B as it presently stands, and 21C. There was a third provision. That third provision permitted disqualification for activities outside the house. Now, I haven't got the exact provision, but I'll get it by this evening and tender it. Because we only just discovered this. The third one was removed. By debate, it was deleted. 21C was deleted, and your lordship will just see one. It's at PDF 38, your lordship can just note. Where is the marked part?